I am Dan Jerome Barrera, and I'm going to share to you the Cybercrime Prevention Act of 2012, or the Republic Act number 10175. And aside from this, I will also be sharing to you other issuances of the Supreme Court related to cybercrime, fighting cybercrime, and the advisories of the Department of Justice Office of Cybercrime. But before anything else, let me share to you first some Bible verses. Proverbs chapter 10 verse 9, it says here, "Whoever walks in integrity walks securely, but whoever takes crooked paths will be found out." In other words, integrity is the key word here. If we act, if we talk, if we walk with integrity, we will feel secure and we will be secured. How can we achieve peace in our lives? It's by being honest, by having integrity in our lives, in our actions, and everything that we do. Because if we do dishonest things, deceitful things, if we lie, if we cheat, if we steal, we will never have peace in our lives. But whoever takes crooked paths will be found out. Sooner or later, these people who walks not in integrity, they will be found out in their crooked paths. Another one, Proverbs chapter 11 verse 3, "The integrity of the upright guides them, but the unfaithful are destroyed by their duplicity." Do not worry if you are wrong. Do not worry if some people lie and steal, because someday they will be found out, and someday they will be destroyed by their duplicity, because God's goodness will rule, God's goodness will be lifted up, God's goodness will win over the battle against bad, crooked, wicked things in this world. Just like what we have now in the cyber world. Some people do things that affect our systems, that affect many people, that steal their money online, but sooner or later they will be found out. Just like these people, the XSOX group and the Mark Nagoyo group. No, these are cyber criminals. For example, the SXOX group, they were arrested by the Philippine National Police ACG because they hacked the Smartmatic system of the COMELEC recently. This year they hacked, but they only managed to hack the preparation stage. They were not able to hack the entire system, the election system, and they were arrested thanks to our Philippine National Police ACG. We will discuss who are these people behind the arrest of these people. Next one, the Mark Nagoyo group. They bypassed the PIN, the passwords, one-time passwords of the account holders of 700 bank accounts, 700 bank accounts, and they drained the money from the bank accounts to one account of Mark Naguyo in Union Bank. So hundreds of thousands were lost from the 700 bank accounts and they transferred to a certain Mark Naguyo account. Imagine the loss that these people experience from the hands of these cyber criminals. So this is the problem right now. The cyber world fight against crimes is not only limited in the physical world. The fight against crimes is also extended in the cyber world. So how do we fight cyber crimes? How does the Philippines fight cyber crimes? First, it employs a certain legal system. Second, it employs certain legal processes. And third, it defines cybercrimes and prescribed penalties. Of course, we need to define the problem in order to identify it and do something against it in order to solve the problem. So these three topics, these are the topics that I will be discussing this morning. So let us start with the legal system. What is the system and what does our country use? What kind of system and what are the components of this system in fighting cyber crimes? Of course, in the physical world, we have the criminal justice system. If you remember, there are 5 pillars of the criminal justice system in the Philippines. We have the law enforcement, prosecution, courts, correction, community. In the cyber world and in fighting cyber crimes in the Philippines, we have also these pillars. We have the law enforcement, prosecution, courts, correction, community. And also what's unique with this system is that there are coordinating agencies. This is what oftentimes the criminal justice system in the physical world lack the coordinating agencies. So these coordinating agencies make the fight against cybercrimes unique from the fight against crimes in the physical world. In the physical world, the criminal justice system lacked the coordinating agencies. But in fighting cybercrimes, there are coordinating agencies. So we have the law enforcement now, prosecution, courts, correction, community, and coordinating agencies. So what are the components of law enforcement? We have 2 law enforcement groups under the PNP and NBI, specifically PNP Anti-Cybercrime Group or PNP ACG, and the NBI Cybercrime Division or the NBI CCD that exclusively focus or handle cybercrime offenses. Prosecution, we have special prosecutors also of the National Prosecution Service or NPS in coordination with the DOJ Office of Cybercrime. Then we have also courts, special commercial courts designated as cybercrime courts because the Supreme Court deemed the cybercrimes as commercial in nature. So special commercial courts are designated as cybercrime courts. And corrections, of course, corrections are similar from physical world and with the cyber world. So the same correctional system, the PGMP, Bucor, and other correctional institutions handle these offenders. And let's go to community. The prominent members of the community pillar in this legal system are service providers, National Computer Emergency Response Team or INSERT, we'll discuss them later, other governmental units, LGUs, and community in general. You and me are part of the community in general. So we are part of this pillar in fighting against cyber crimes. Our role is to report, to complain against cyber criminals when they commit cyber crimes against us or any other persons or systems in the country. And we have lastly coordinating agencies. This is what makes again our fighting cyber crimes, the legal system in fighting cyber crimes unique because we have these coordinating agencies so that the operations, the planning, the policies will be polished, will be fine-tuned, there will be cooperation, there will be coordination among agencies, so that there will be no overlaps, there will be no conflicts of rules, conflicts of laws, etc., etc. So what are the coordinating agencies under this system? Number 1 is the Cybercrime Investigation and Coordinating Center or CICC. We'll discuss them later in detail. And the other one is the DOJ Office of Cybercrime. This is the operational center of the CICC. Again, the Office of Cybercrime or OCC is the operational center of the Cybercrime Investigation and Coordinating Center. So let's discuss in detail Cybercrime Investigation and Coordinating Center or the CICC. The CICC is under the supervision, directly under the supervision of the President of the Philippines. So it is an independent body under the Office of the President of the Philippines. What are its duties and functions? Number 1, policy coordination and national cybersecurity planning. So it plans our cybersecurity of our country, and it also coordinates policies among agencies, among implementers of cybercrime law, and among other institutions so that there will be uniform rules, uniform templates, uniform policies against cybercrimes. So that these agencies will work hand in hand in fighting cybercrimes. Second, monitor cybercrimes. The CICC monitor, conduct researches, gather statistics, gather data about cyber crimes, gather intelligence against cyber criminals, and so on and so forth. Next, it facilitates international cooperation through the DOJ OCC. Again, the DOJ OCC is the hand or the operational center of the CICC, and it facilitates international cooperation through the OCC, DOJ OCC. So there will be foreign counterparts of the CICC, of the OCC, and the PNP ACG in other countries. You know that cybercrimes are committed extraterritoriality, meaning one person can commit cybercrimes in the Philippines while he is outside the Philippines. He could be in China, he could be in the US, he could be in Europe, hacking our system here in the Philippines. So we need international cooperation in fighting against these type of cybercrimes and cyber criminals. Last is call upon other agencies and community stakeholders to render assistance. Now, the DOJ OCC, the PNP, ACG, and the NBI CCD cannot handle alone these problems, so they need assistance from other agencies, especially the community pillar. So this is the organizational chart, administrative organizational chart of the CICC. It is led by the Office of the Executive Director, and under him is the Deputy Executive Director. You can see here on the upper right corner, the Executive Committee. It is an interagency. This is the brain of the CICC. We'll discuss them later after this slide. So under the Deputy Executive Director, we have Administrative and Finance Office, Cybercrime Investigation Office, Cybercrime Policy Plans and Coordination Office, and under these offices, we have different offices and groups also, or divisions. And lastly, we have also legal division under the Office of the Executive Director. And let's now talk about the brain of the CICC. So the brain of the CICC is composed of these following persons. The Chief Executive Committee, the Chairman of the Executive Committee is the Executive Director of the DOST, Department of Science and Technology, Information and Communications Technology Office. So his or her Vice Chairman is the NBI Director. And the members of this Executive Committee are the PNP Chief, the Chief PNP, the DOJ OCC Head, and one representative each from the business sector, from the non-government organization, and the academe, or from schools, from the universities, from colleges. So one representative from the academe. So all in all, there are 7 members of the Executive Committee, the brain of the CICC. You can learn more about the CICC by visiting their page at cicc.gov.ph. So let's talk about the second coordinating agency. So the DOJ Office of Cybercrime, this is the operational center of the CICC. It coordinates NBI-CCD, PNP-ACG, and the National Prosecution Service. So these are the prosecutors. So this is what makes fighting cybercrimes unique because the NBI, the PNP, and the prosecutors, they form a task force under the DOJ Office of Cybercrimes to conduct case build-up, to prepare the case, and to file the case in court. So there will be cooperation among the law enforcement and prosecutors. Unlike in the physical world, in fighting crimes in the physical world, there is somewhat a divide among these agencies. But here in fighting cybercrimes, there will be coordinations because of the DOJ Office of Cybercrime. This is the task of the OCC, to coordinate these agencies. Next is to coordinate with foreign counterparts. So as I said earlier, cybercrimes can be committed while the hacker is outside the Philippines. So we need to coordinate with other foreign countries in order to arrest or to effect arrest or to effect extradition, deportation, and so on and so forth. So next, assists in investigation. Then acts on complaints and cause the investigation and prosecution. So it investigates, it helps the NBI, it helps the PNP, it assists in giving training, giving education to our law enforcers, and etc., etc., and acts on complaints and cause investigation and prosecution. So it orders the PNP, NBI, and the National Prosecution Service to do investigation and prosecution as the case may be. So you can visit and you can learn more about the DOJ Office of Cybercrime by visiting their site at doj.gov.ph/Office of Cybercrime HTML. Next, let's discuss the other pillar of the legal system against cybercrimes. We have the PNP-ACG and the NBI-CCD. What are the powers and functions of the PNP-ACG and NBI-CCD? Number one is, of course, investigation. They investigate cybercrimes, the occurrences, the complaints, the reports on cybercrimes committed within the Philippines. Data recovery and forensic analysis. So they are also capable in analyzing computers, our cell phones, and so on and so forth if they are part or involved in cyber crimes. They formulate guidelines, develop public relations with the community pillar to inform the community members their role in the legal system, database maintenance on cyber offenses, complaints, capacity development to train law enforcement officers and other entities that are involved in fighting cyber crimes, and to support also the national cyber security plans. Most likely and usually the PNP, ACG, and NBI-CCD is the implementing organs of the government. They implement the cybercrime laws and policies. You can visit the ACG, the Anti-Cybercrime Group of the PNP, at acg.pnp.gov.ph/main/ so you can learn more about that. In that website also, you will learn that they are hiring cybercrime cops. So if you are qualified, you can apply as a cybercrime cop in the PNP Anti-Cybercrime Group. Now let's discuss the members of the community pillar. We have first the Computer Emergency Response Team, or CERT. The national CERT is under the ICT DOST. It serves as the coordinator for cybersecurity, and its activities are in two areas. Number one, incident response. Number two, proactive service. So whenever a particular cybercrime at a national level is being conducted against critical infrastructure in the Philippines, we'll learn about what is critical infrastructure. CERT is being called upon because these are experts. Members of the CERT are experts in analyzing cybercrimes. So their assistance will be summoned by the OCC to help the PNP and the NBI Cybercrime Division to analyze, to suppress an ongoing cybercrime threat. So we call this incident response. And its another job is proactive service. It conducts vulnerability assessment. It assesses the government agencies, our critical infrastructure, whether there is enough security to guard our infrastructure, the cyber security plans of our country. So these are the experts who will do that. So they extend assistance to CICC, they issue guidelines on cybercrime, cyber security plans, and provide technical trainings to our law enforcers, and of course technical analysis, things that could not be done by the PNP or the NBI. These people can handle them. So technical analysis. You can visit their webpage at insert.gov.ph. You can see in that webpage they flash there the incidents. For example, the incidents that they handled. For example, from January 1 to December 31, 2021, they handled 1,174 incidents, cybercrime incidents. Now you can visit the page to learn more about this. Next part of the community pillar, service providers. What are service providers? Under the law, they are defined as any public or private entity that provides to users of its service the ability to communicate by means of computer system. How are we able to communicate with each other? For example, if we communicate through text or through chat, so we use Messenger, we use Viber. So Viber, Facebook, they are the service providers. If we use our cell phone to call each other, to send text, so the Globe Telecom and other telecoms, smart telecoms, due to telecommunity, these are the service providers. What are their duties? Number one is to preserve traffic data, subscriber information, and content data. We'll discuss thoroughly what are these type of data later. Next, they collect data or assist the law enforcement agencies in collecting computer data, and they also block and report child pornography. If there are child pornography materials on their sites being spread by users, they could block and report them. That's their duty. Now, we have learned already the legal system, or who are the people and what are the institutions and agencies that handle cybercrime offenses to prevent and suppress them. Now let's go to what are the processes that this system uses to fight against cybercrimes. What are the processes? What are the steps? What are the procedures? What are the legal procedures? Because you cannot directly go to the house of the suspect, enter his room and get his cell phone and open the cell phone right away after commission of a crime. You cannot do that, except in some circumstances which we will discuss later. So, first question, when does a cybercrime case start? How is it instituted? How is a cybercrime offense or case instituted? So, it is instituted by, number one, you can go to the law enforcement agency. You can file a complaint directly with the Philippine National Police ACG or Anti-Cybercrime Group. Here in our province, we have in the provincial office, we have the ACG there, or to the NBI CCD, or directly file the complaint with the prosecutor's office. Or a cybercrime case is started or starts or is instituted upon lawful arrest without a warrant. So let's discuss them individually. So there are three instances. So number one, filing a complaint with the police. When do you file a complaint with the police? When you can also file your complaint directly with the prosecutor's office. You can go to the prosecutor or you can go first to the police. So when do you go first to the police? And when do you go directly to the prosecutor's office? So we'll answer these questions. Number one, you go to the police, you file the complaint with the law enforcement officer when the following are necessary. Number one, when it is necessary for case build up, to do case build up. What does this mean? What is case build up? To gather the evidence, to identify the identity of the perpetrator, to get hold or to disclose the certain computer data from a certain computer device. We need a case build up. In other words, when you have no sufficient evidence against a person committing cybercrimes against you, you go first to the law enforcement officer and they will be the ones to do case build up. So when it is also necessary, number two, for the issuance of the preservation order. We'll discuss what is preservation order later. It is an order by the OCC, Office of Cybercrime, ordering a service provider to preserve the data, because that data, content data, subscriber information, or traffic data may be used in the future in a particular case, in a hearing in the court, or in the trial, or any other purpose. So the law enforcement officer can order the service provider to preserve the data. Another one, when it is necessary for a court warrant to disclose computer data. Of course, you cannot, as I said earlier, you cannot go to the room of the suspect and get his cell phone there immediately and open the cell phone. No, you need a court warrant to do that, and court warrant to search and seize data. Next, you can go, but you can also go directly to the prosecutor's office. You can file the complaint directly to the prosecutor's office. When is it proper? When you have already enough evidence. So when you see that you have already enough evidence upon the advice of your lawyer that you have enough evidence already, you can file your complaint with the prosecutor's office if you deem it that you have already enough evidence. Well, if you do not have enough evidence, as I said, do not go directly to the prosecutor's office. Another one, when the crime has a prescribed penalty of at least 4 years, 2 months, and 1 day imprisonment. So cyber offenses, as we will learn later, are included in this criterion. They pass this criterion of penalty of at least 4 months, 2 years, and 1 day. So because these cases that have at least 4 years, 2 months, and 1 day imposable imprisonment penalty require preliminary investigation. What is preliminary investigation? It is investigation conducted by the prosecutor's office to determine whether there is probable cause to believe that a crime has been committed and the suspect might be probably guilty of the accusation against him. So that's preliminary investigation, and the prosecutor does it. So it is different from criminal investigation that the police will do. Preliminary investigation is the job of the prosecutors to to receive the complaints, to require the suspects or the respondents to submit their counter affidavits, to ask questions from both sides, and both sides to gather more evidence from them, and to determine whether there is probable cause. If there is probable cause, the prosecutor will file the case to the court. So that's what we call preliminary investigation. It is different from the criminal investigation conducted by the law enforcement of agencies. Now, when is lawful arrest without a warrant conducted? So it is another instance when a cybercrime offense or case is being instituted. So lawful arrest without a warrant may be conducted in, number one, in flagrante delicto. When the offender, cybercrime offender, is caught in the act committing a cybercrime. So if a law enforcement officer has witnessed that a particular cybercrime offender has just committed, is committing, or is about to commit a cybercrime, so he can in effect an arrest. So the case will start from that moment. Or by hot pursuit. When the officer has personal knowledge that a crime has just been committed based on facts and circumstances, and that he could arrest, no, by hot pursuit. This is a continuous pursuit from the crime, discovery of the crime, and he has the personal knowledge that a cybercrime is committed, so he can conduct hot pursuit. And after that, after arresting, so the arresting officer, he will bring the cyber offender to the police station, and the prosecutor will conduct inquest. It is a summary proceeding to ask some questions to determine whether there is reason to continually detain the suspect and file the case directly to the court without undergoing preliminary investigation. So instead of preliminary investigation, only inquest will be done and conducted by the prosecutors before filing the case to the court. But of course, the suspect can demand for a preliminary investigation during this stage. So these are the moments when cybercrime offenses or cases are instituted. Now, how are complaints filed? Of course, one can file directly or walk-in filing of complaint directly with the PNP ACG and the NBI CCD or the prosecutor's office. But one can also file a complaint. So if you are victimized by a cyber criminal, you can file a complaint online, no, to lessen the hassle in going to and from the PNP and the NBI CCD offices. So you can go to the acg.pnp.gov.ph complaint/open.php in order for you to file your online complaint. Or you can go to the cicc.gov.ph. No, in filing your complaint, you can submit a cyber complaint there. So you can input the required information. You can attach some documents, some evidence to support your claims. Now, how is your complaint? So after you file a complaint, how is your complaint being processed? So here is a simple enumeration of the steps on how our cybercrime complaints are processed. The first step in processing cybercrime offenses is done by, so last column, OCC, PNP, ACG, or NBI CCD. So they receive the complaint and logs the complaint in the record book and provides the complaint a receiving copy of that that record. Then, what are the documentary requirements? It is required that the complainant shall present the complaint affidavit or sworn statement, and together with the attachments or the evidence to support the claims, the screenshots, the receipts, etc. The second step is to contact the reporting party, the complainant. No? The PNP, SCG, NBI will contact the complainant for additional information. Then the law enforcement officer studies the complaint. This is step 3. It studies the complaint and gathers evidence. And step 4, issues preservation order. This is the job of the OCC. This is a typographical error. It is OCC, not OOC. It is the Office of Cybercrime, so OCC, DOJ. OCC is the one that will issue preservation orders addressed to the service provider. So upon the recommendation or application of the PNP, ACG, or NBI CCD, the OCC will issue a preservation order addressed to the Globe, to Smart, to D2 Telecommunity, or to Facebook, to Viber. They will issue preservation order to preserve the data. We'll talk more about this later. The fifth step is that the PNP, the law enforcement officer, will administer oath, issue subpoena on a suspect, and summons witnesses to appear in the investigation or proceedings for interrogation, for questioning, for interrogation, interview. So next, step 3, conduct enforcement operation if warranted. So if it is necessary to conduct enforcement activities to gather more evidence, to search, to seize the computer data, so there's need for court or search warrant. So the law enforcement officer will apply before the court for the grant of these warrants. Next, when the law enforcement officer receives the device already or seized already the device, so the law enforcement officers, the PNP, ACG, or NBI CCD, will have to conduct forensic examination to look into the data inside a computer. Next, they file the complaint with the National Prosecution Services. And the last is that the prosecutor will conduct preliminary investigation. So these are the steps in processing the complaint just before the trial. So next, we go now to this process of preservation and retention of data. But before that, let us first learn what are the types of data. Number 1 is traffic data. What are traffic data? Traffic data are any computer data other than the content of the information. So these are not the content of the information, but it is all about the origin. Where does the information come from? The destination, who is the receiver of the information, the route, the time, the date, the size, the duration or type of underlying service. Is it a text? Is it a chat? Is it a post? So that is what we call traffic data. Next, subscriber information. So information about the subscriber, like you and me, the name, relating to the subscribers of its services, so like our name, or other information, identifying information that we have online. So that's what we call subscriber information. Next, content data. So the content itself, the chat itself, the text post itself. So we call that the content data. And lastly, this term is important, computer data. Representation of facts, information or concepts, program, electronic documents, and other or electronic data messages. So we can see this as encompassing all of these other types of data. So computer data can mean traffic data, it could mean subscriber information, it could mean content data. So let's now go to preservation and retention of data. What is this step all about? So we have on the first column the type of information, second column duration of preservation, and third column inception of preservation. So in traffic data and subscriber information, the inception of preservation, inception meaning the start of preservation, when does the service provider start preserving this information, traffic data and subscriber information? They start preserving traffic data and subscribers information from the moment of transaction. Transaction from the moment. What is transaction? From the moment when somebody texts, send a text, somebody posts on Facebook, somebody posts on YouTube, somebody tweets, somebody send you a direct message, a chat or a text, somebody calls you. So that's the start of the preservation. So under the law, under this law RA 10175, the service provider, the Globe, the Smart, the Facebook, are required to preserve our traffic data. They have the data about ourselves. They have the data of the traffic data. They have the data about our names, about our numbers. They have it in their system. And what is the duration of preservation? At least 6 months from the moment of transaction. So 6 months from the moment of transaction. How about content data? When does preservation of content data? We know that content data is the content itself of our message, the message itself, the text, the chat, the post itself. No, the service provider shall preserve them for 6 months after the receipt of preservation order from whom? From the Office of Cybercrime, DOJ Office of Cybercrime, upon the application of the NBI CCD and the PNP ACG, and it is extendable one time 6 months extension. So it could be 1 year. So from 6 months to 1 year, as the case may be. If it is extended for another 6 months, so it's become 1 year. How about computer data in criminal case already? So until final termination of the case or as ordered by the court. So if the computer data, either traffic data, subscriber information, or content data, are used in a trial or are used in a criminal case, so until the termination of the case up to the Supreme Court, if the case is being appealed up to the Supreme Court, until the final termination. So when does it start? It starts when the data is used in a case, of course, and the receipt of the copy of transmittal document to the prosecutor's office. So if the law enforcement officer will give the service provider the copy of the transmittal document, the complaints and so on and so forth, relevant to a certain criminal case against this cyber offender. So the receipt, the time of the receipt is the start of the preservation until final termination of the case up to the Supreme Court, if the case is appealed before the Supreme Court. So that's my apology, this is duplication. Let's now go to disclosure, interception, search, seizure, and examination. This is an exciting portion of our law. When does a law enforcement officer, when does a police officer of the PNP ACG disclose a certain information, or intercept, or search, or seize, or examine the information from our cell phone? For example, the cyber offender has a cell phone inside his bag, and after arrest there is a cell phone, and if a law enforcement officer sees the cell phone, can he open the cell phone? The answer will be determined and the question will be answered later. But before that, we will first define what are computers. What does a computer mean? So it refers to, this is the technical definition, it's too long, refers to electronic, magnetic, optical, electrochemical, or other data processing or communication service, and etc., etc., etc. It's easy to understand if we look at the examples like mobile phones. So our mobile phones are computers, smartphones, computer networks, our PCs, our laptops, and other devices connected to the internet. If your television or TV is connected to the internet, it is a smart television, it's considered as a computer, or any other device connected to the internet. They are computers. So what if a law enforcement officer wants the service provider to disclose the computer data? Of course, the OCC, the Office of Cybercrime can only order the service provider to preserve the data, but the OCC cannot order the service provider to disclose the data. What's the difference? So in the preservation order, the service provider will just have to preserve the data without disclosing the data. So they just preserve, they keep the data from being lost or from being destroyed or being intercepted by any other person or being altered by any other person. But in the matters of disclosing the computer data from the service provider or any person who who holds the information or who has a computer, so the police officer cannot go to the service provider and get a computer, or a particular person get the cell phone and open the cell phone to disclose the computer. No, the law enforcement officer must apply for warrant to disclose computer data, or WDCD. So, and after this, after being granted by the court, by the special commercial court or the cybercrime, designated as cybercrime court, the law enforcement officer will issue an order requiring any person or service provider to disclose or submit computer data. This is now the time that the law enforcement officer can issue an order to a service provider or any person who takes hold of a computer to disclose the contents of the computer within 72 hours after the receipt of the order. So when does the law enforcement officer return the information gathered to the court and the disclosed computer data to the court? So within 48 hours, when does the police report to the court after the disclosure of the computer data? So within 48 hours from, number one, implementation. So from the moment that the police officer implements the order, and finally the data is disclosed within 48 hours from that implementation of the warrant, or within 48 hours after the expiration. So 10 days expiration of the warrant. This warrant expires for 10 days, and the other warrants, but extendable for another 10 days, as the case may be, if permitted by court. So that's disclosure of computer data. Next, interception of computer data. What if the law enforcement officer wants to see the actual conversation through text or chat between terrorists or between drug traffickers? What if, or between the cyber criminals, their text, their conversation, so another information real time? So how do they do this? So will they directly hack the cell phones of the terrorists, of the cyber criminals, or the drug traffickers? No, they must first apply for warrant to intercept computer data, or WICD. So after being granted of the warrant, now the law enforcement officer can listen to, record, monitor, or conduct surveillance of the content data. This is now the time that they can do this. They can listen to the conversation, they can record the conversation, they can monitor, they can conduct surveillance. Then after return, what is the period of return? Within 48 hours from implementation. So the same as earlier. Or 48 hours from expiration. So with 2 days. So within 2 days after the first 10 days, but extendable for another 10 days, as the case may be, if permitted by court. Then after 48 hours, after the return to court of the evidence gathered and the report of the law enforcement officer to the court, within 30 days after return, the law enforcement officer shall notify the person whose content data have been intercepted. So if the content data is intercepted, for example, I have a cell phone and it is hacked by the PNP ACG to monitor my texts, my conversations, because if I were a cyber criminal, so I'll be monitored by them. So within 30 days, I will be informed by the PNP ACG that, hey, Dan Jerome Barrera, we intercepted your data. So imagine how awkward this situation is if it is implemented. Next, search, seizure, and examination of computer data. Can you search right away? Can you seize the cell phone right away? Can you examine the what is seized right away immediately without warrant? No, you cannot do that. Even if you have already seized a cell phone after a lawful warrantless arrest, you cannot open the cell phone. Although there was a case decided in 2014 by the Supreme Court. This case was in 2005 or 2006. A group of robbers and one suspect left his phone in a taxi, and the cell phone was seized by the police officers, and the police officers opened the cell phone and to see the messages, and they used the messages to pinpoint the locations of other suspects, and they arrested the suspects, and the evidence was used in court, and the Supreme Court ruled that the evidence could be used. However, this was done before the cybercrime law, before we have all these rules. So I doubt if that case, the People versus Inoha's case in 2014, decided in 2014 by the Supreme Court, can be applied now. But there are no recent cases about this. But according to our law, current law, you cannot do that. After seizing the cell phone from the suspect, you cannot open it right away without a warrant. No, as the law enforcement officer should apply first for warrant to search, warrant to seize, and warrant to examine computer data. So the law enforcement searches the particular place if being armed by this warrant, but only the place designated in the warrant. If the warrant says search the room of Juan, so you only search the room of Juan, not the other room of Maria, or the CR, or the other place, the backyard. And no, you search only the place designated in the warrant. And for a particular items, do not search for other items. You are only commanded by the court to search for the cell phone of Juan in Juan's room. Do not search for his computer, laptop, because you are only told to seize the cell phone. And after seizing, you make a forensic image to copy the data inside the cell phone. If you cannot do that, you go to off-site examination to the laboratory. So of course with the permission of the court. So the law enforcement officer, if armed with this warrant, may also conduct interception of ongoing conversation of content data of the offenders. So the LEO may order the data holder provider to provide information to undertake the search, seizure, and examination. So for example, if you go to the house of Juan and you have already seized his cell phone, but you have no password, you cannot open the cell phone. So you have now the power, based on this warrant, to order the person, the owner, Juan, or anyone who knows the password of the cell phone to give you the password to open the cell phone. So you have the power, if you have this warrant, to order the person to give you the password and open the cell phone using those passwords given. The period of return, this is unique because there are three phases in the period of return. There will be first initial return. This is within 10 days from the issuance of the warrant to search, seize, and examine the computer data. So within 10 days, so you report to the court what you have gathered, the information, the devices that you have seized, and so on and so forth. Then there will be, and the court will give you time to examine the cell phone. He will give you time, for example, 10 days, 20 days, and this time is extendable up to 30 days. So the examination of the computer and the data inside the computer, the cell phone, the PC, the laptop, can be examined up to 30 days, depending on the number of days the court will give you if you are the law enforcement officer. Then there will be final return within 48 hours after examination. So after you have examined the cell phone, so after 48 hours, within 48 hours after that examination, you return to court. You give the information that you have gathered, you give the report to the court that this is what we do, what we did, this what are the things that we found, etc., etc. Next, examination after warrantless possession of computer. This is what I said earlier. There was a case when the police officers seized the cell phone of the suspect. The suspect fled, and they could not find the suspect, so they used the cell phone to trace the other suspects and the suspect himself. So so can you now do it? Can you do it nowadays with this new law that we have? No, the answer is no, because first you must apply for warrant to examine computer data. So after you have already been granted of a warrant, you have already the warrant to examine the computer data, so you can now search the computer's device or system after warrantless arrest or seizure, in flagrante delicto, or voluntary surrender of the unit. So if the suspect voluntarily surrenders the cell phone, you cannot open the cell phone right away. So the safest thing for you to do, no, so that not to waste your effort, because if you violate these rules, the evidence that you will gather will not be accepted by court. If you examine the cell phone without a warrant, the evidence that you've gathered will not be accepted in court, and your case might be dismissed. So you might waste your effort. So do not do that. The safest thing is to get a warrant, to apply for warrant from the cybercrime court, a special commercial court designated as cybercrime court. So here are the period of return. So the same as earlier. So we have the initial return, we have examination, and final return. So 10 days from the issuance of the warrant. The WECD is just typographical error. So within 10 days from the issuance of the warrant, to report to court what you did, what you found, what information you gathered, and you'll be given time by the court to examine, and this time is extendable up to 30 days. And within 48 hours after examination, you conduct final report to the court, bring the information, bring the devices, and so on and so forth. So now we have already learned the legal system, the legal processes in fighting against cybercrimes and cybercriminals. Right now, what are we fighting against? So let us define what are cybercrimes. What are the different cybercrimes? So there are 4 types of cybercrimes enumerated under RA 10175. So here are the 4 types. First type, offenses against the confidentiality, integrity, and availability of computer data and systems. If you and me have a cell phone, we have the right of confidentiality and the integrity of our data of our cell phone or computers. We have some records in our computers, and if somebody erases the record, erases the data, or changes the data inside our computer, that's a crime. So because it is our right to be secure in our persons, in our papers, in our computers, and the availability of our computer data. Of course, we have our computers. It is our property. If somebody will just automatically turn off our computer remotely by planting viruses in our computers, and we cannot use anymore our computers because they plant virus to destroy the system of our computers, that is a crime. So this is the first type of crime, cybercrime. Offenses against the confidentiality, integrity, and availability of our computer data system. So first, illegal access. By the way, the second type of cybercrimes are computer-related offenses. The third type, content-related offenses, and the fourth type are other offenses. So let us discuss the first type. So we have illegal access. So from the word illegal access, so you access a computer, you access a cell phone illegally. So without right. So just like the case earlier when the SOX group accessed the computer system, the Smartmatic computer system, they illegally accessed the computer system. So one crime that could be charged against them is illegal access of the system. So what is illegal access, the access to the whole or any part of the computer system without right. So just like entering a house, just like trespassing a house, entering a house without a right. So that crime is similar to that. This crime is similar to illegal access of a computer system. So illegal access, the access to the whole or any part of the computer system. Illegal, next type of cybercrime under first type, illegal interception, from the word illegal, so without right, and interception. So let us define them. Illegal interception made by technical means without right of any public transmission of computer data. So non-public meaning private transmission of computer data from or within the computer system, including electromagnetic emissions from a computer system carrying such computer data. So if we for example we log in Facebook, we log in YouTube, or we log in our email, we use passwords, we use our usernames. So if the hackers will plant viruses to gather our passwords, so that's illegal interception. They intercept the data that we use online, so that's illegal interception. Next, data interference. So to interfere the data, so change the data. No, this data interference is like online graffiti, online or cyber graffiti or vandalism online. Now, intentional or reckless alteration, changing, damaging, destroying, deleting, or deterioration of computer data, electronic document, or electronic data message without right, including the introduction of transmission of viruses. So if you have a website and that website is being destroyed, being hacked, being changed, being altered, that's data interference. If we have if you want to destroy all the data of your university, to delete all the data we have in our system, in grading system, that's data interference. Next, system interference. So earlier, data interference, destroying the data or altering the data. Now, system interference. So altering, destroying the computer system itself or the computer network. So if I have a laptop and my laptop will be attacked, so that will be planted with a virus, and I could not use my laptop anymore, it will not turn on. If it turns on, somebody will turn it off remotely, so I could not use my computer. So that's system interference. So intentional alteration or reckless hindering or interference with the functioning of a computer or computer network. Next, misuse of devices. So if the offender has already gathered my password or the information in my credit card, and they make another fake credit card, and they use that credit card and they use my password, that's what we call misuse of devices. Not only using, not only production, not only sale is being prohibited under this offense, but also possession of said devices. So if a person possesses a credit card, or if a person possesses a fake credit card using my information or my password, so if you possess that information, that person can be charged of this offense, misuse of devices. So using or possession, so misuse of these devices. Next, cyber squatting. So like just similar to squatters, so squatting a land, there is also cyber squatting. What is it? So acquisition of a domain name over the internet in bad faith to profit, mislead, destroy reputation, and deprive others from registering the same. So it is commonly done by offenders in, for example, if you enter a website, for example, the website of Jollibee, but when you click the website of Jollibee, you are redirected to a pornographic site. So you cannot enter anymore the website of Jollibee because they plant a virus there, they plant something in that website. When you click that website, you are directed to another website. That's cyber squatting. Or somebody uses the name of Jollibee, just to tweak the name, not just to fool other offenders. For example, Jollibee, Jollibee. So if somebody changes and makes a domain name, the www.ja, instead of JOJALLIBEE, that's still cyber squatting, because that is important. Because for example, PayMaya, if you PayMaya is a for fund transfer for payment. What if you just change the name, you have your own domain name, the PayMaya, instead of PAY, you make it P-E-Y, Maya. So to create confusion, that if the victims will enter into your website to pay something, and but you gather their information and use it, so that's cyber squatting. Next, computer-related offenses, meaning you conduct these offenses using computers. So computer-related offenses. First, forgery. So computer-related forgery. You conduct forgery using computers. Now, what is it? Input, alteration, or deletion of any computer data resulting in inauthentic data with the intent that it be considered or acted upon for legal purposes as if it were authentic. For example, if somebody has a criminal record in the system of the Philippine National Police or the NBI, and that person wants to get a clean clearance, because he will apply for job abroad, and he needs a clean clearance that he has no criminal record. So if he hacks the system of the NBI or the PNP to delete, to alter that he has no criminal record, in fact he has a lot of criminal records in the system, if he deletes his records in the system with the intent that it be considered acted upon for legal purposes, so that he can receive a clearance that is clean, to make it as if as it is authentic, so that is computer related forgery. Or if somebody fails in a subject and wants to change the grade, if he hacks the computer of the teacher and change the grade himself into pass, or the computer system of the registrar, the e-grading system, to change the grades so that it will appear that he passes, so that he will receive a diploma, or he receive a transcript of records, clean passing records from the school, and he will graduate. So that's computer related forgery. But not only that, not only the doing, but also the using of the forged data for dishonest gain. So that using also is prohibited. Next, computer related fraud. So the input, alteration, so changing or deleting any computer data with fraudulent intent. Not changing the data, altering the data, or deletion of computer data so that one can gain money. Fraudulent intent, the scams, and so on and so forth. So computer related fraud. Next, identity theft. So the acquisition, use, misuse, transfer, alteration, or possession or deletion of identifying information belonging to another, whether natural or juridical, without right. So if somebody takes over your Facebook, not you, he uses your Facebook profile, he uses your Facebook account, that's computer related identity. He will post something, he will post some malicious things on your wall, acting as you, using your Facebook profile. That's identity theft, computer related identity. Another example, if somebody orders through Food Panda or Grab Food using your name, he or she orders thousands of pesos worth of merchandise using your name, and it is cash on delivery, and the delivery riders arrive in your house asking for payment, and you do not know that you did not order, and you do not know who ordered. That's computer related theft. We have so many incidences of this. That's computer related theft. So it is a computer related offense. Next, content related offense, from the word content. So it's all about content, what you do with the content, what we do with the video, what we do with the text, what the post. No, computer related. So these are prohibited contents. So this is about suppressing some communication, some posts, some communications online, because they are detrimental to our peace and order, or security or privacy of another person. Number one, cyber sex. So cyber sex, what is cyber sex? Willful engagement, maintenance, control, or operation, directly or indirectly, of any lascivious exhibition of sexual organs or sexual activity. So usually there are people who use women to exhibit their private parts online for money, for gain, so that they will have more subscribers, they will receive money. So they will use these women to exhibit dancing or caressing online, or to perform sexual activities, sexual intercourse with the aid of computer system for favor or consideration. We call that cyber sex. So committed by, what if the women use our children? It's not cyber sex, so we now call that as child pornography. If the women used in the video, in the audio, are children below 18 years old, that crime is now called child pornography, and it is punishable under RA 9775. So it is any representation, whether visual, so it's a video or pictures, audio, whether the voice of the child, or written combination thereof, or combination of the picture and the audio, or the video and the audio, by electronic, mechanical, digital, optical, magnetic, or any other means of child engaged or involved in real or simulated explicit sexual activities. Real, if it is real, in fact, it is a real sexual activity, the child will demonstrate a sexual activity online, or simulated, a fake one, simulated explicit sexual activities online. That's what we call child pornography. Next, libel. What is libel? This is very popular and very common online. So a public, according to the revised penal code, a public and malicious imputation of a vice or defect, crime, real or imaginary. So even if it is real, magnanakaw, kawatan, even if it is real, and you post that on public that Maria is a thief, Maria is a robber, even if it is real, no, if it is real or even imaginary, that can cause the contempt, discredit, or dishonor of a person. That is what we call libel, and you do it online, that's online libel. But by the way, you might notice that under content related offense, under RA 10175, we have there the fourth content related offense, the unsolicited commercial communications, or in other words, spams. Now, spams are not included here. I did not include them here because spam, the provision of spams has been declared by the Supreme Court as unconstitutional, because it is a right, because commercial communications are protected by our right or freedom of speech. So, fourth type, other offenses, aiding or abetting in the commission of a crime. So any person who willfully abets or aids, if you help a cyber offender to commit any of these offenses except child pornography and libel. So if you help any of the cyber offenders, no, if you provide cell phones, if you provide computers, knowing that they will commit a cybercrime, so that's aiding or abetting cybercrimes. But of course, if you are in conspiracy with them, you will be punished under these other offenses. But if you do not, you are not a conspirator, but just supply them materials, so that's aiding or abetting. Next, attempt in the commission of crime. So all of these crimes, if they are consummated, so the offender will be punished under these offenses. But if the offense is just being attempted and the offender is stopped from consummating the crime because they were arrested on time before finally consummating it, or under causes independent from their will, so that's attempt in the commission of crime. So any person who willfully attempts to commit any of the offenses enumerated in this act shall be held liable. So in this law, there is consummated cybercrime and attempted cybercrime, no frustrated cybercrime. So once the offender has done the cybercrime, this is automatically consummated cybercrime. If he just attempts, so no frustrated cybercrime. So let's now go to the penalties. So this is very exciting. So the first type of cybercrime offenses, here are the penalties of the first type of the cybercrime offenses. Number 1, illegal access. Number 2, illegal interception. So the penalty for illegal access is prison mayor, so that's 6 years and 1 day to 12 years imprisonment, or a fine of 200,000 pesos up to the maximum amount commensurate to the damage. So it depends on the court to determine the amount of damage of the system committed by the cyber offender, or both. What does it mean? Both prisión mayor and a fine of at least 200,000 pesos. So if the court will say that, I'll just imprison you, I'll just fine you, or I'll imprison you, at the same time I'll fine you of at least 200,000 pesos. So that's within the bounds of the law. So either imprisonment of prisión mayor or a fine of at least 200,000 pesos, or both imprisonment or fine. So the same penalty is prescribed for illegal interception. So what if these cyber offenses are committed against critical infrastructure? The penalty, if it is committed against critical infrastructure of the country, is either reclusion temporal, that is 12 years and 1 day to 20 years imprisonment, or the judge will decide a fine of 500,000 pesos up to a maximum amount commensurate to the damage, or both reclusion temporal and fine. So it depends on the discretion of the court, either reclusion temporal, 12 years and 1 day to 20 years, or a fine of only 500,000 pesos up to maximum amount commensurate to the damage, or both imprisonment and fine. The same with illegal interception committed against critical infrastructure. But what is critical infrastructure? These are computer systems or networks, whether physical, virtual, or computer programs, computer data, or traffic data, so vital to this country. What are these? Example, the COMELEC Smartmatic system, the COMELEC election system, that is so vital in the country. What if on the day of the election, all the data will be lost, all the data of the voters will be lost, all the Smartmatic machines have been hacked? So that is so vital in the country. That's critical infrastructure. How about the infrastructure of our national defense system, the infrastructure of our train system? Our trains is run by computers, and the traffic system. What if they will hack the traffic lights? No, there will be accidents. So that's this is so vital to this country. What else? The clearance system. There are so many. The ID system. There's so many that are so vital that if they are hacked, that they are destroyed, or the data have been altered, there will be debilitating impact. So there will be destruction, there will be huge bad impact on security, national or economic security, national public health and safety, or any combination of those matters. So the same with data interference and system interference. So the same type of penalty, either imprisonment, fine, or both. And prisión mayor, or fine of at least 200,000, or both. And if committed against critical infrastructure, reclusion temporal, or a fine, or both reclusion temporal and a fine. Next, misuse of devices. So the same penalty of cyber squatting if committed against cyber critical infrastructure. So the same reclusion temporal, or at least 500,000 pesos, or both of them. Next, letter B, second type of cybercrime, the computer-related offenses. What are the penalties? So what are these crimes? Computer-related forgery, computer-related fraud, computer-related identity theft. So the penalty is either prisión mayor, 6 years and 1 day up to 12 years, or a fine of 200,000 up to one maximum amount of commensurate to the damage, or both, or prisión mayor, or a fine of 200,000 up to the maximum amount commensurate to the damage, or both, or prisión mayor. So the same across all of these computer-related offenses. Next, content-related offenses, cyber sex, child pornography, and libel. So 1, 2, we skip to 4 because number 3 is about spam. So we'll discuss about it later. Why I discussed this earlier. Why I excluded them. The unsolicited commercial communications. The penalty for cyber sex is prisión mayor, 6 years and 1 day to 12 years imprisonment, or a fine of 200,000 up to 1 million pesos, or both imprisonment of prisión mayor and a fine of 200,000 up to 1,000 pesos. So cyber sex involving a child shall be punished by Republic Act number 9775. We call that child pornography. The penalty is 1 degree higher than that provided for in RA 9775. So if the offenders use computers to propagate child pornography, so that is 1 degree higher. So the use of computers is considered as an aggravating circumstance to increase the penalty. So aggravating circumstance is the use of a computer. How about libel? Prison correctional maximum, this is maximum to prison mayor minimum, or a fine of 6,000 up to a maximum amount determined by court, or both. So is provided by the revised penal code, but applicable only to the author of the post. So what does this mean? If there is a libelous post by somebody who says that Juan is a thief, Juan is a robber, is a family of thief, so it discredits, dishonors Juan and the family of Juan. Who is liable there? If somebody shares also the post. So the liable only is the author of the post, the person who posted it. But the person who shared the post will not be liable. He is not the author, he just shared. Or somebody who comments, or somebody who likes the post. So he is not the author, so he is not liable of libel. The same with now in unsolicited commercial communications or spams have been declared, provision of this has been declared unconstitutional by the court. So spams are protected by our freedom of speech. So unsolicited commercial communications is not a crime anymore. Next, other offenses: aiding or abetting in the commission of a cybercrime, or attempt in the commission of cybercrime. So 1 degree lower than that prescribed penalty for the offense. So if somebody helps a hacker to hack the Comelec system, somebody who provides the computers, now without conspiracy, without being a principal by induction, principal by indispensable cooperation, or principal by direct participation, he will receive 1 degree lower than the prescribed penalty. So 1 degree lower if the penalty is prison mayor, so 1 degree lower is prison correctional, or a fine of 100,000 pesos up to 500,000 pesos, or both, except child pornography or online libel. Because if you share the post, you are not aiding or abetting. If you share the post of libelous post or a child pornography, if you like it, of course, do not like child pornography. No, that will destroy your soul. I tell you that it can cause addiction to you, and so on and so forth. It will compromise your spiritual being if you subscribe to children pornography. So don't do that. How about online libel? If you share the post or libelous post against someone, you will not receive any penalty because you just share it. But my advice is do not share it, because it will destroy another's reputation. It will multiply his agony. Next, attempt in the commission of cybercrime, 1 degree lower than that prescribed penalty, so the same. So if somebody attempts to hack the system of Comelec, just attempting to hack, but he has not really hacked it or not accessed it, so that's an attempt. So 1 degree lower is prison correctional. If it no, not prison correctional, because if it is a critical infrastructure, that's reclusion temporal. So the 1 degree lower of reclusion temporal is prison mayor. So that's it, except for child pornography and online libel. How about the ordinary crimes under the revised penal code? If they are they are committed through the use of computers or use of information and communication technology. For example, malversation of public funds. Malversation, if conducted by the mayor through the use of computers, so the penalty is 1 degree higher than that provided for by the revised penal code and special laws. Next, corporate liability. So what is corporate liability? Liability of the particular corporation, the leader of the corporation who hacks another corporation so that his own corporation will gain profit. So that's an example. So the juridical person, the corporation itself, shall be fined at least double the fines imposable is 200,000 in the if committed by a person, if it is conducted by a leader in a of a juridical person or a company, juridical person, companies, state, the local government units and other entities, so we call that juridical person. So double the fine, so 200,000, so 400,000, then up to the maximum of 10 million pesos. The same if I just left out the second here. The second penalty is for the ordinary employee under the supervision of the leader, but the leader does not supervise him properly, and the employee hacks another company for the benefit of his own company. So that company will be meted out with a fine, double the fine, so the same, and up to 10 million pesos. What are juridical person? The state or the Philippines political subdivision, the LGU, the units, or any agency, other corporations, institutions, entities for public interest or purpose created by law, like state universities, government-owned and controlled corporation, or corporations, partnerships, and associations for private interest of private corporations, partnerships, associations. So if their leaders or employees under the supervision of the leaders who did not supervise properly the leaders, so the corporation whose employee hacks another corporation for the benefit of their own corporation will be liable for fines, double the fines, up to 10 million. So that's it. Thank you for listening. Have a good day. That's the Cybercrime Prevention Act of 2012, or Public Act number 10175, and related issuances of the Supreme Court and the DOJ advisory. So we have learned already the legal system, the legal processes, and the definition of cybercrimes and the penalties thereof in order to fight this type of crimes. So my advice to everyone is to preserve your integrity, to walk with integrity so that you will walk securely. God bless.